for members who are absent or on official business. I have apologies from Councillor David Humphreys, who will be substituted for by Councillor Clues. An apology from Councillor Jens, who is substituted by Councillor Bates. An apology from Councillor Fowler, who is substituted for by Councillor Smith. Are there any other apologies? Are you happy, members, that we note those apologies? Thank you. I should have done the evacuation procedure first. Sorry, I dived ahead of the agenda. So we are not expecting any fire alarms or tests or anything else. So if you hear the fire alarm, it's likely to be a real event. If that occurs, please leave the building by the nearest safest exit, which is likely to be that door. If that's not available for whatever reason, it will be the entrance to the civic suite that you all entered the building by. As you're aware, we have a register of health warnings here for safety purposes. So if the alarm does sound, please don't just go home because it runs the risk of us sending a fireman into a potentially dangerous building to find you when you're at the chip shop. So please stay with us. The evacuation point is assembly point G, which is just outside on the car park, and stay there until tonight's proper officer, Sophia Ali, says it is safe to go home. Do we have any disclosable pecuniary or non-pecuniary interests? Councillor Smith?
Yeah, non-pecuniary interest on agenda item 5E due to personal proximity to the site.
Thank you. Councillor Bell?
On the one that's on the board, Chairman, only that I did join one of the Sunday protests against the animal welfare issues to do with that site, but it was nothing to do with planning.
Councillor Clues?
The property's on Westwood Crescent. I do live on the Crescent, but it won't be my property that's being done.
Thank you. Councillor Jack? No, sorry, Councillor Colonel.
I attended a couple of the protests.
Councillor Jackson?
I'm just, thank you, Chair. I'm just here as a guest speaker tonight, but I'd like to declare my pecuniary interest in the abattoir because I've attended meetings, protests, and we've stood with residents for a long time. Non-pecuniary.
Councillor Hogley?
That's the same to me, Chair.
Thank you. Are we all happy to note those declarations? Members, you might be aware, maybe not aware, between the last meeting and this one, we've had an election. And that election has resulted in changes to the council's constitution. 4 members who previously served with significant distinction on this board are no longer members of the board. So I'd like to formally record our thanks to Councillor David Riley, Councillor Debbie Bates, Councillor Judy Gosling, or ex-Councillor Judy Gosling, and Councillor Katie Hobley for their sterling work. Are you happy that we formally write to them thanking them for their contributions? Members, you will, no doubt, within that, be surprised to see that said Councillor Debbie Bates and Councillor Katie Hobley are with us tonight. And I know that some of them will be with us for quite a few meetings in the future, and genuinely, to both of you and to others, please do keep coming back and saying that your experience as members of the board is invaluable. And the more experienced members we have, the better. So thank you both, and please stay with us. And within your respective parties, tell them just what a mistake they've made and get you back on. But we will now contact those former councillors. I'd also like to take the opportunity to welcome our new councillors. Thank you for being silly enough to agree to join the Planning and Development Board. We will hopefully make it helpful, useful and entertaining. Jokes are always welcome. Members, you will also no doubt have seen that we have a reasonable number of people in the public gallery. I believe that a lot of people are here to discuss the issue in respect of the Arley Abattoir. So you'll see on the front we are going to change the agenda and bring that item forward to the beginning of the agenda so we don't keep people hanging about for longer than is necessary. Are you all happy that we do that agenda item first?
Yeah.
Thank you very much. So we have two speakers who will wish to address us. The first of which is Mr. Dave Owen. Mr. Owen, if you take the speaker's chair while Mr. Brown introduces his report.
Right, thank you, Mr. Chairman. I'll just run through the slides, and again, for the new members, these are replicated in the papers that you have in front of you. The site there is outlined in red. As you can see, residential area next door to the public house, which is referred to in the report, and the terrace of properties opposite, with again a house opposite next door. The current layout that we have is that, and you can see the buildings at the back in the solid black lines, and also the entrances and exits, as you can see there. That was as it was existing, and we've also got an aerial photograph as it was, and you can see that, which is replicated in the papers that you have in front of you. I need to update the board as things have been moving since this particular application was, since the agenda was published. You'll see that the recommendation is one of refusal, and you'll see that in the report, particularly at sort of paragraphs 4.9, that sort of area in the report on the third page, that at the time of writing this report, the plans that we'd received didn't reflect what was on the site. In other words, the plans were missing several items, and that's outlined there in paragraphs 4.7, 4.8 and 4.9. Since the report has been published, there's been an indication from the applicant that they now intend to submit amended plans which properly reflect what's on the site. They arrived on Friday. We haven't reconsulted anyone yet on because they were not complete. We are expecting those plans to come in the next couple of days, and the case officer has been in touch with the applicant's agent, and you may hear a bit more about that later, Mr. Chairman, from the other speaker, as to when they're likely to come in. I'm not proposing, therefore, to reconsult until the whole package, as it were, is in. And that reconsultation will take place with the Environmental Health Officer, the Highway Authority, and clearly with local residents. So as a result of that, Mr. Chairman, and given that the recommended refusal reasons are based on insufficient information, I would strongly recommend that the recommendation is changed to one of deferral, so that in fact everybody can get themselves up to date with the current set of plans that have come in, and also hear the consultation responses from the Environmental Health Officer and the Highway Authority. That is frustrating for officers, it's frustrating for members, and it's frustrating for the public. But given the actual reasons for refusal, I don't think you're in a position to do anything else, but you may wish to take advice from Sophia on your right on that. Needless to say, that means if the deferral does happen tonight, we'll have to report it back to you. And it's my intention to report to the next planning board, which is June the 9th, Monday, June the 9th. Hopefully by then, we'll have the written responses from the consultees. If they don't come in, Mr. Chairman, we can do a supplementary report, or I can report verbally. But I am aware this has to be resolved one way or the other. And therefore it's our intention, given the responses that we may have from the Highway Authority, to report back to you on June the 9th. So my recommendation to the board, Mr. Chairman, is at the present time, and in these circumstances, is one of deferral.
Thank you, Mr. Brown. Can you give the board any assurance that this will definitely be for determination at the next meeting?
We've already warned, in inverted commas, the Highway Authority that there are amended plans in, and I spoke to the Highway Officer this morning, and therefore he will get advance warning of the plans, and he will receive them before anyone else, because clearly one of the reasons for refusal relates to highway matters. The residents are here tonight I'll particularly ask if they could get any comments back to us before June the 9th, preferably 4 or 5 days before June the 9th, so they can be incorporated into the papers. But as I've said, I'll report anything through a supplementary report or verbally if that is necessary. But it's my intention to report back on June the 9th.
And look, I'm not going to predetermine what the board is going to say, but I think there will be significant disquiet if we didn't make a decision on June the 9th. Bear with me. Any guidance on that?
We need to consider all information before making the application, not granting either permission or refusal. Should we not take into account everything, it could lead to appeal.
Okay. So look, we have a bunch of speakers who've taken the time and trouble to come and talk to us. I think we should at least hear what our speakers have to say and then take a decision over whether we're going to defer or not. Councillor Brown.
Thank you, Chairman. I've got another question for Mr. Brown. So has the applicant been given a deadline by which he must submit this information? Otherwise, we could be in the same position again on June the 9th.
Precisely, Mr. Chairman. As I said, half of this information came in last week. The case officer indicated to the applicant what was missing. And from the conversations I've had in the past 24 hours, the case officer is indicating that information is coming in the next 48 hours. So I needed it in by the end of this week. If I'm going to meet the June the 9th. The applicant, Mr. Chairman, is one of the speakers, or the applicant's agent is one of the speakers. And no doubt when he speaks to the board, he may be able to give an up-to-date indication of when that is likely to be submitted.
Councillor Waffle.
Thank you, Chair. I was just going to say as well, if people have taken time to come tonight to speak, can we make sure that we have taken that on board for the next board meeting? Because if they're not able to come and have already spoken anyway, I think it's only fair that we make sure that that is heard within our decision making if we do defer to the 9th.
Absolutely, but
Thank
bear
you.
in mind that the application may vary between now and determination. So yes, but bear in mind there could be changes to it.
The similar lines, to be honest, Chair. I'm just wondering if speakers speak tonight, do they still have the right to speak at the next meeting?
Absolutely.
That's fine. Thank you.
Mr. Owen, welcome to the council house.
Thank you.
I'm sorry that you have come. We may ask you to come back, but generally, welcome to the meeting. My colleague will explain the rules on public engagement.
Good evening, welcome. You have 3 minutes to speak. I'll start the clock when you start speaking.
Can I ask a question before? Is there any point in me speaking at this point if I'm going to repeat virtually the same stuff at the next meeting?
Entirely your call.
I'm a bit disappointed that the last minute we've just been told to come all this way.
I can absolutely appreciate your frustration. We have to go with the rules as we find them, I'm afraid. So to make a safe decision one way or the other, we have to obtain the additional information.
Can I consult with my colleagues if it's worth doing it at this point? Or
Yes.
Yes.
Democracy in action, Mr. Chairman. Can you hear me now?
So, you ready to start time?
Yeah, I'll remind you when you've got 1 minute remaining. So I'll start the clock when you start speaking.
Okay, thank you. To those entrusted to represent us, I stand before you, sitting down in this case, not just as a retired business consultant, but as a resident of Old Arley, a village we chose for its peace and community and its very essence. 5 years ago, my partner and nurse and I invested all our savings to rebuild our retirement here. Drawn by the gentle rhythm of the village life, we embraced Old Arley, and Old Arley embraced us until now. The arrival of this industrial slaughterhouse has shattered the tranquility we sought and the community we cherished. The pervasive, sickening stench has made our homes unbearable. Our garden once havens of peace are now no-go zones. We are prisoners in our own houses, unable to enjoy fresh air or even walk our dog without fleeing the revolting smell. Once minimal traffic was exploded, the 26-ton lorries thundered through our narrow lanes, often before dawn, blocking pavements and endangering pedestrians. This isn't a quiet village we moved to. It's a noisy, polluted industrial site. Old Alley was a haven for retirees and long-standing families. Now fear and anxiety ripple through our close-knit community. We worry about arson. We're disturbed by the constant noise and deeply concerned about the children in the nearby school, a place for vulnerable children. We have witnessed appalling behaviour, spitting, offensive gestures, public urination, and illegal parking on the slaughterhouse staff. The charming former butcher shop, once adorned with flowers, has been brutally transformed into a concrete eyesore, an industrial facade complete with noisy extractor fans that can be heard.
1 minute left.
The reputation of Old Alley has been dragged through the mud, and news of animal abuse, arson, and protests paint a grim picture, undoubtedly diminishing the value of our homes and quality of our life. If nothing is done, the Old Alley will fade away forever, associated with death and suffering. We are the victims here, along with the animals. We demand justice, we demand to be heard. You, our elected representatives, have the powers to end this injustice. I implore you, vote against the planning application, save our village, otherwise you are voting to support animal abuse and neglect of your own constituents. Thank you.
Thank you. Thank you, Mr. Owen. Members, do you have any questions for our speaker? No questions, so thank you very much, Mr. Owen. Our next speaker is Mr. Sadiq, who's joining us by Teams. Mr. Sadiq, welcome to the meeting. My colleague will explain the rules on public engagement.
Good evening. You have 3 minutes to speak. I'll start the clock when you start speaking. I'll give you a reminder that 1 minute's outstanding when it's outstanding. I'll start the clock when you start speaking.
Thank you. Dear Chair and Councillors, thank you for allowing us to speak on behalf of the client. We would request a deferment as all the relevant information has been provided to the planning officer, and there's some remaining specification that's required, which will be with yourselves by this Friday afternoon. So the request is to ask for a deferment in order for the application to be looked at with the relevant information, and hopefully we can then go through a full hearing on next month's committee hearing. So the request is that if we could ask for a deferment, please. Thank you.
Thank you very much. Members, do you have any questions for our speaker? Councillor Clute?
Thank you very much. You did say that the paperwork would be with our planning officers this Friday. Could you make us a promise of that, please?
Yes, Andrew's asked for some specification that he requires, and we should have that for Friday for him.
Thank you very much.
Any other questions, members? No, in which case, thank you very much, Mr. Sadiq.
Thank you.
Now, I'm aware that some non-members of the board, councillors, would like to speak. So would you like to speak now or later?
I'd like to speak now if possible. Yeah, please. Doesn't work. Okay. So, Chair, thank you, Chair, members of the committee and fellow residents. I'd like to thank you for the opportunity to speak today, as I'm here as a guest speaker. I'm here as a local Labour councillor and stood with residents in firm opposition of this proposed abattoir development in our local village. There are multiple serious grounds for refusing this application, which I will outline now. First and most urgently, the Highways Authority has continually objected to planning, stating that this site is not safe for the volume and type of lorries that would need to access it. Beyond that, there is an additional deeply concerning issues that these lorries cannot safely turn within the site, and they often have to reverse onto the main road. This leaves local residents at danger. This is not only highly impractical but dangerous. These residents have to frequently walk along this pavement directly adjustment to that road. Families, children and elderly people. The presence of these reversing HGVs in such close proximity is a real and present risk to pedestrian safety. As stated in the HGV regulations, livestock trailers have noted impact on visibility, particularly when reversing. As such, spotters, vehicle cameras and sensors are encouraged to ensure that pedestrians are not harmed, plus the animals are not harmed at the time too. These protections also support traffic and pedestrians, keeping them safe from blind spots caused from the rigid construction of the livestock trailers. This is a small village, it's not an industrial estate, and such traffic movements are entirely inappropriate. Lorries are also frequently blocking access for other traffic, causing disruption and frustration for residents just trying to go about their daily lives. There's also a lot of lorries that park up on the path, which is blocking residents from being able to use the path, which is making it really difficult for mobility scooters and wheelchairs as well. My second reason is the appearance and scale of the proposed development are completely at odds with our rural village. The use of the industrial shutters, large metal gates and Velux-style roof windows may be common in commercial or industrial zones, but they are not suited to our countryside setting. This would disrupt the rural character, contravening local design guidance for policy NW12 and the National Planning Policy Framework Chapter 12, paragraph 130 and Chapter 16, paragraph 192. This guidance requires new developments to reflect and respect the character of their surroundings. My third reason, I must raise a significant concern regarding the certificate of lawfulness issued to this site. It is understood that this was granted on the basis that its current use is a continuation of the previous business. However, if that statement was misleading, false or complete, the council has the power to revoke the certificate under Article 39 of the Town and Country Planning Development Management Procedure. The previous business only slaughtered roughly 200 animals each week at the most. We estimate, based on the current volume of traffic that residents saw on site, they slaughtered between 800 and 1,200 animals each week. Let me remind the committee it is a criminal offence to knowingly provide false or misleading information in support of a certificate. If this has happened, not only could the certificate be revoked, but the applicant could face legal consequences. This must be taken seriously, and I ask that if any doubt at all, the committee resolves that this matter is investigated thoroughly and referred to the relevant authority. Oh, sorry. There are many other reasons why I think this slaughterhouse should not be accepted for the planning application. There is also another item that hasn't been given out to the public, but at the moment we believe that there's a meat packing process going on at the moment, which is also a change of use, and that should be investigated too. Finally, the community has come together, not out of resistance to change, but out of a shared belief in the safety, identity and well-being of our local village. With the support of the Highways Authority, local and national planning policy, and the voice of the local residents behind us, I ask you today to say clearly this application is not suitable for this location. Thank you.
Councillor Hobley, do you want to?
Yes, thank you, Chair. I just want to add to Councillor Jackson's comments. My sincere thanks to the residents of Old Arley, who've tirelessly campaigned not only against animal cruelty, but against poor highway safety, all the huge changes that the abattoir has impacted such a lovely village. Councillors on all sides of this chamber, Councillor Bell, Councillor Humphreys, and of course the ever persistent Councillor Jackson, who has worked, tirelessly, given so many hours to this. They've had to show unity and to act on the needs of our residents, and also remembering previous councillor, now MP Jodie Gosling, also keeping our residents informed. To all the officers that have put their time in, Jeff for all the meetings that he's organised, and for you, Chair, to allowing us all to come and speak on this application, for your time and diligence for this process to ensure that it is a fair and just end result for our residents. To everyone who has been involved with this, who've worked so hard, and for the residents who are not only here today, but who are living through this. That's why all of you councillors are supporting you. And whilst I understand the deferment's very frustrating for the residents, I believe it's the right thing to do to get all the information so that no stone is left unturned with this process. I fully trust this process. And I know that the board will do the right thing when it comes to it. So thanks for letting us speak, Chair. I really appreciate it.
Thank you. Does any member of the board wish to speak before we move to a vote rather on deferment?
I have a question, if I may. Quite simply, it's this. We appear to have been given an undertaking tonight by the applicant to get all of the facts to us in time for them to be processed, so that this can be determined at the next planning meeting. Can we ensure that it actually does go to that meeting if they fail to bring that information to us? Will that affect the possibility of what will happen in the future? Is it something that we can legally do, or do we have to waste everybody's time if this information doesn't come until later?
Legal opinion first?
We're going to have to just wait and see whether the information comes. If we take a decision that it needs to go to the next planning board, we would. But we'll have to wait till Friday.
Planning opinion?
I'll report whatever I have, Mr. Chairman, to you on June the 9th. That's all I can do. That's in terms of the material that comes in from the applicant and also the consultation responses that I have. As I've said, I can certainly place it on the agenda. I can do a written supplementary report, which may arrive 24 hours before the meeting, and I can also update verbally. We will get it onto the agenda, but with the information that I have at that time.
Opinions from me.
For the benefit of everybody here, we will be following what the law tells us that we've got to do. We cannot deviate from that.
Oh, well, broadly, yes. But my view is, members, you've had an assurance from the applicant's representative that he'll get that information to us. You members of the board will be making that decision. I can tell you that my vote on deferment or otherwise, should it arise next time, will be not to defer, because we've had an assurance that the information will be provided. Deliberately not prejudging what information is being provided, merely the efficiency of board meetings and not sort of taking too long to make decisions on this. It's an important issue that we need to reach a landing on. So my own view is, yes, of course, we'll listen to what he said, we'll hear all the views, but I would be extremely disappointed if we weren't able to make a decision. So, members, I'd like to propose that we defer discussion of this until our next meeting and make sure that we do make a decision at our next meeting. Can I have a seconder? Thank you. All those in favour? That's unanimous. Thank you very much. Members of the public, I'm sorry you've had a bit of a waste of time, but I'm sure you've appreciated what you've heard from members who have spoken. If you'd like to leave the meeting now, you are perfectly at liberty to go and find something better to do. Thank you.
Thank you.
Members will go on to agenda item number 4, which you probably noticed I missed, which is the minutes of the last meeting. Are you all happy that I signed the minutes of the true and correct vote? Thank you. Any again? No, that's great. Thank you. We'll go on to the rest of the agenda now. So the next application is number 40 for 91 White House Road, Thornton. Mr. Brown, anything to add to your report?
Nothing, just to show you the slides, Mr. Chairman. Again, that's a photograph which is replication of the papers in front of you.
Thank you very much. Members, any comments, questions? Councillor Jarvis? Those recommendations. Thank you. Thank you very much. All those in favour? That's unanimous. Thank you. We move to application number 27 for land between Homefield and Oakdean, Bent Road, North Crawley. Mr. Beverley has indicated that he'd like to speak. Mr. Beverley, if you take the Speaker's chair while Mr. Brown introduces his report.
Again, Mr. Chairman, I'll just start off with the plans, and I'll leave that one up. It's the two bungalows, as you can see there, one at the front of Bennett's Road North and the one behind. The second slide is just an elevations, but I'll leave the layout on the front of you. There's a history to this particular site, and it's explained fully in the report in front of you. Again, there's a change in circumstance here, and members will be familiar with that, given the previous discussions that we had previously on the introduction of grey belt as a result of the MPPF changes at the end of last year. And therefore, this application has come in on that particular basis. First of all, we do agree that this land is PDL, that's previously developed land. That's explained in the report, but that does not automatically mean that planning permission should be granted. And the reasons for that are set out in the report. It also, as you can see from the report, does qualify as grey belt. But that again does not mean it's automatically granted approval. There are conditions attached to grey belt land. Those are explained in the report in some detail from 9/11 onwards, in fact 3 or 4 pages, as to the reasons why we consider this to be inappropriate development in the green belt. As is inappropriate development in the green belt, a very special circumstances case has to be met, and that has been shown not to exist in 3 past appeal decisions. And they are all outlined in the report in front of you, with copies of the decision letters as well. This remains the case now. So this, with this current application for the 2 bungalows, so therefore it is previously developed land. It is grey belt, yes, but it is not appropriate development in the green belt for the reasons given in the report. And we do not consider that the balance lies with granting a planning permission as such that very special circumstances do exist. Thank you, Mr. Chairman.
Thank you, Mr. Brown. Mr. Beverley, welcome back to the Council House. For the avoidance of any doubt, my colleague will now explain the rules on public engagement.
Good evening. You've got 3 minutes to speak. I'll start the clock when you start speaking, and I'll remind you that you've got 1 minute outstanding when you have 1 minute. That's fine. I'll start the clock when you start.
Thank you very much. Good evening. The use and development of all land and buildings in England are governed by the planning system. The government's planning policies are set out in the National Planning Policy Framework, which was renewed December 2024. Local and neighbourhood plans should be prepared in line with this. Firstly, Firstly, and most relevant to the application, is paragraph 154 of the National Planning Policy Framework, December 24. Development in the Greenbelt is not inappropriate if G. Limited infilling or the partial or complete redevelopment of previously developed land, which Mr. Brown says it is, which would not cause substantial harm. This is the main change, substantial harm to the openness of the Greenbelt land. Yes, there's been 3 previous appeals. Each inspector stated only moderate harm to the openness would be caused by building on the site. Thus, it passes the test and complies with National Planning Policy Framework. Doesn't matter, it's not green, it's grey belt. This isn't on, yes, it could be grey belt, but paragraph 154 states it's not inappropriate if it doesn't cause substantial harm. 3 inspectors have already stated it's only moderate harm to the openness, so it cannot be substantial, thus it should be passed. Thank you very much.
Thank you, Mr. Beverley. Members, do you have any questions for our speaker? In which case, thank you. Thank you very much.
Thank you.
Given what we've just heard in terms of Greenbelt, is there any legal guidance you can give us one way or the other on this?
It's relatively new, grey belt, green belt, so there's quite a lot of uncertainty regarding this. So we can only tell through case law, which is it's new, so it's uncertain what can be classed as green, what can be classed as grey at the moment.
Thank you. Councillor Jones.
A question for Mr. Brown, if I may. A little bit confused when you say it's grey belt, but then it's inappropriate in green belt. Could you clarify that, please?
It's in the report, Mr. Chairman. There's 4 pages explaining why that is. It is grey belt. Therefore, you have to move to paragraph 155 of the PPG of the NPPF. That's outlined in the report. And for it to be appropriate development, it has to satisfy 4 conditions, all 4 conditions. The report goes into at length why it does not meet at least 2 of those. That's the reason why it is not appropriate development. And it's all explained in the report, Mr. Chairman, at great length.
Can I just clarify, Mr. Brown, that the use has to meet all of the requirements?
Absolutely, that's set out in the NPPF. And it was clarified in February this year through a ministerial statement.
Councillor Bell?
Yeah, thank you, Chairman. I'm a bit confused now because our legal advice is it may be grey belt, but Mr. Brown is saying it is grey belt. So is it or isn't it? And also, I mean, I'm not as familiar with the NPPF as our speaker is, but the speaker seemed to put forward a really sound case, actually, quoting the NPPF. Has he missed out paragraphs that would have been against this case? Yeah, 2 questions, thank you.
Thank you. Mr. Brown?
2 things. First of all, from a planning point of view, it is a grey belt. And I've got the report actually explains the reasons for that. So this is grey belt land in the green belt. In terms of the paragraph number which Councillor Beverley has referred to, I agree that paragraph 154 is in there. However, there have been 3 appeal decisions which have led to dismissals, and there's also the introduction of the paragraphs on grey belt. So therefore, whilst we can consider paragraph 154, you've also got to consider the grey belt paragraph. So you've got to combine those 2. Mr. Beverley's only just referred to one of the paragraphs, not to both of them.
Councillor Hayfield?
Thank you. Yes, I accept that there's been 3 appeals upholding refusal
on Greenbelt grounds, but there hasn't been an appeal upholding refusal on Greenbelt grounds. And Jeff says it sounds very clear. It's not clear in my own mind. I know the area well. I know the site well, and I can't see substantial harm in this application. I see the recommendation. I'm sure I shall be persuaded, but I almost want. Is there any point in a deferral on this to sort of examine these issues more closely?
I'm in the board's hands, Councillor Hayfield. I think there are substantial issues here in terms of the decisions referenced by 3 inspectors who've made a determination, but I think it is undoubted that the government's introduction of Greybelt into the national planning policy framework as our legal guidance is that it's different. So if you would like further guidance as a board on exactly what that means, then I think the only appropriate way will be to defer for that. On the other hand, if members are comfortable that you have understood the issue, then you are free to make a decision. Councillor Wobble.
Thank you. That's a great suggestion from Councillor Hayfield, but I just wonder, where would we seek this advice from? Because we've got our advisors here today, and I'm just wondering what else we could get in order to inform us further.
I would just caution you, Councillor Hayfield doesn't normally come up with great suggestions. But what I suppose I'd be looking for is one of the things I was going to talk about later on this evening was the need for training. Greybelt is relatively new, and we're all new to that. So I think what I'd be looking for is a joint discussion with our legal advisor and our planning officer as to exactly what the circumstances here are. Not to determine the application, because you can only do that in this room at a board meeting, but to provide background information to enable you to more fully understand the issue. The decision can only be made here, and I wouldn't wish anyone to get the view that we're going off into a private room to have a chat and make a decision. Absolutely not. But to explain what the legal background, the planning background is, I think that as part of training is perfectly reasonable. Do you have a...
No, I totally agree, yes.
Councillor Hayfield, another great suggestion from you, perhaps?
No, I would feel more comfortable proposing a deferment on the basis that the lines you've been talking about on this. So I won't express a view on the actual application until it comes back to us.
Thank you. And I saw Councillor Parsons, then Councillor Clue.
Thank you, Chair. I'm drawn to the fact that this has gone to 3 appeals, and inspectors have come down against it on 3 occasions. And whereas we do have this introduction of the Greybelt area, which may be new, what I'd really like to know is, was the Greybelt definition a factor in the final appeal? It wasn't, no. In which case, if I think possibly the deferment is...
Councillor Clue?
Yes, yeah.
Sorry, Chair. Yeah, I'm a bit like Councillor Waffles. If we're being told one thing and then we're not sure about the other, you know, should we defer and just get our heads together a bit more? Or, you know, but it has been going on for a while. Thank you, Chair.
Councillor Ridley?
Thank you, Chair. My understanding as a planning geek is that Greybelt is still Greenbelt. So consequently, although it is previously developed land, it still has to be considered as it is per Greenbelt. So effectively, it still has a strong planning balance, and there are other issues to take into consideration along with it, i.e. the housing need, the sustainable location. So it all sort of goes towards actually making a decision on the planning balance. But Greybelt is still Greenbelt. There is just, but like our legal expert sort of says, the problem is there hasn't been a lot of stated cases in relation to what is grey, what is green, and how that is sort of like driven forward. I know there has been some, certainly on the edge of London, Essex, there was one recently. But when it comes to sites such as this, within our rural setting, I think it has a different impact. But yes, certainly, I think it's a good call to say perhaps we could look at this in more depth and
Thank you. And your understanding matches mine, that the grey belt is still within the green belt. It's just that the NPPF has different criteria. But as the report has tried to set out, you need to meet all 5 of those, and view is not. But look, 4 rather. And then if it's development within the green belt, it needs to have very special circumstances. But members, I genuinely am aware that this is something that is relatively new, and I think to be sure that you are comfortable, that you have the appropriate information, I think I'd rather we deferred for one meeting to enable you to have that comfort to then make a decision. Councillor Jarvis?
I think listening to all members, there's a degree of confusion and on the number of grey area around this that needs some clarification. I'd be happy to second Councillor Hayfield's proposal for deferment.
Thank you. Members, we've had a proposal for deferment, which has been seconded. Are there any other proposals before we take a vote?
Just confirm that it's for training and not to consider this application behind the doors.
Absolutely. No, just for the avoidance of any doubt, this is to enable members to be trained on the issues, not to consider the application as part of training. You'll be trained on the issues, and that will then enable you to make a decision on this application, not that we'll have a meeting to determine the application. It's so that you can understand the context, particularly given the relatively recent introduction in the NPPF of grey belt. We're all clear on that. We all understand what we're referring to.
No grey areas.
Well done, Councillor Hayfield. So can I take a vote, please, on whether to defer so that members can be trained, and then we come back to this application after the training. All those in favour of deferment? And any against? That's unanimous. So, Mr. Beverley, we'll defer the further consideration of your application. We'll come back to this at our next meeting in a month's time.
Can I put in a statement in the meantime that everybody can read?
A statement to members?
Yeah.
Yes, absolutely.
Okay.
No, you can email any councillor at any time, and you don't need our consent for that. That's your democratic right as a member of the UK community.
Because some people have, obviously the training might put it through.
No, I'm happy for you to do it, but I can't have a discussion with you right now.
Yeah. Because not everything that's written in that report is relevant.
And I can't have a discussion with you.
No, okay, thank you very much.
Thank you.
Thank you.
Members, we now move to application number 41 for 10 Austrey Lane, Newton Regis. Mr. Brown, anything to add to your report?
No, Mr. Chairman, again, just the photograph which is replicated in the papers that you have in front of you. It's another access.
With the recommendation, Chair.
Thank you very much. Any? So I presume you were both seconding it rather than wishing to speak. So it's been proposed and seconded. Can I see those in favour of the recommendation? Unanimity again. Members, we now move to application number 577 for land to the north of Park Lane Farm, Park Lane, Astley. Mr. Steve Boundy has indicated he'd like to speak. If you'd like to take the speaker's chair while Mr. Brown introduces his report. Mr. Brown.
Right, thank you, Mr. Chairman. Let me just run through the slides first. Again, the side, I don't know how clear it is. It's the red line there, which you can see is this area here, and the access goes down to Nuthurst Lane. The village of Astley is here with the crossroads, and New Arley is over here. Astley Gorse, which is referred to in the report, is this woodland here. And you can see the other woodland, which is referred to in the report, which is just south of the recreation ground at Hilltop in Arley. The layout This one shows the footpath which runs through the site, from Nuthurst Lane that runs through the site up to Arley. That's some of the buildings which members are familiar with now from the applications they considered. This shows the two sites. It's referred to in the report as an extension to Ashley Gorse, an established where a planning permission has already been granted. That grant of planning permission is for this site, and that was granted a couple of years ago. And this one is the current application site, as you can see, with the access being the same. And as you can see from the report, Mr. Chairman, it would have its own separate infrastructure, and it will be developed after this one. Work is going to start on that quite soon. In fact, they're already doing works to the access if members have driven up and down Nuthurst Lane, and this one will follow on. So there'll be separate works, but it's described as an extension in the report in front of you. Again, Mr. Chairman, grey belt comes into this in the report, and again, the report goes in some length as to why this is grey belt land in the green belt. That's explained in some depth in the report. It's therefore then a question, as I've said on the previous case, as to whether it is appropriate development or not appropriate development in the green belt. And again, I've gone through all four conditions in paragraph 155 of the NPPF. And this particular case, we found that in fact this is appropriate development in the green belt. It meets all of the conditions. And that's unsurprising, Mr. Chairman, because this was the case. This is some of the arguments that were discussed at the recent Longley Solar Farm appeal. So therefore, that they're quite these are quite well rehearsed. So therefore, that means there's no green belt reason for refusal, as it is appropriate development in the green belt, and therefore a very special circumstances case, it does not have to be made out. However, you still have to look at the balance. In other words, you still have to look at the harms that are caused and balance those against the benefits. And as you can see from the report, Mr. Chairman, the harm side of the balance is set out in 553. At the most, it's moderate harm. And I think members that visited the site will hopefully agree with that particular conclusion. Moderate visual harm, mainly because of the footpaths that crosses through the site. Limited landscape harm, less than substantial heritage farm, and there's also the loss of BMV. The applicant's considerations on the other side are basically the support given to renewable energy, both in the local plan and particularly in the NPPF and other guidance that the government has published. And again, those are all rehearsed in the recent Longley Solar Farm inquiry. And that leads then to the final balance, which is in section E. In this particular case, the renewable energy arguments are substantial, and the harm side on that side of the balance, the harms are moderate, and therefore the conclusion therefore is that they outweigh the harms, and that's the reason, Mr. Chairman, why a planning permission is recommended to be granted tonight. Just one additional comment. You'll see from the recommendation that it's planning permission to be granted subject to section 106 agreement, and that matter relates to Skylark mitigation. I've discussed this further with the applicant, and several appeal decisions have come through which have dealt with this very same matter, and planning inspectors have actually recommended a condition rather than a section 106. And you'll see in front of you, Mr. Chairman, all members will have a copy of the condition which is being recommended tonight in lieu of the 106. There are 3 papers in front of you, additional papers in front of you, and one of those contains the full wording of the condition which I'm proposing in lieu of the 106. That's me, Mr. Chairman. That's finished.
So, members, can I just check that you have all got this condition? No? In that case, I am going to suggest that you defer this issue until you have the information and can make a decision. We would have deferred in any event for you to have read it, but if you haven't got it, then I don't think we can, in all honesty, proceed.
Thank you.
No, most of us doesn't count. So members, you can, at your decision, defer for a meeting or defer for 10 minutes to give everyone a chance to read it and understand it. But I'm going to say to you quite clearly, if the member who hasn't heard it has questions on it, then I will still be saying you should defer until that member or every member is comfortable. So can I see who would like to, well, let's start out with a 10-minute deferral so to give us all a chance to be sure we've read it. Okay, all those in favour of deferral for 10 minutes? Thank you very much. Well, I don't mean deferment, I mean adjournment. And that'll give those of you who have had it a chance to refresh your memory of what it says.
Yes.
So, everyone has now seen the additional information. Do you understand it? Are you comfortable that you can carry on? Yeah? Okay. In that case, Mr. Boundy, welcome to the Council House. As it's been at least 10 minutes, my colleague will now explain the rules on public engagement.
Good evening, welcome. You have 3 minutes in total to speak. I'll remind you when you have 1 minute outstanding, and I'll start the clock when you start speaking.
Chair, members of the committee, thanks for the opportunity to speak today in support of this application for the extension of the Astley Gorse Solar Farm. The need for increased renewable energy generation is urgent and is within the context of declared national and local climate emergencies. This proposal represents a meaningful step towards a cleaner, more secure energy future. If approved, the Astley Gorse Solar Farm extension is expected to generate up to 28,000 megawatt hours of clean, renewable electricity every year. That's enough to meet the annual electrical needs of over 7,000 family homes. This clean energy will displace an estimated 5,815 tonnes of carbon dioxide per year, compared to conventional fossil fuel sources. Beyond energy, the proposal also delivers a 25% biodiversity net gain, verified by the county ecologist. New hedgerows, species-rich grassland, and pasture management will significantly enhance the ecological value of what is currently intensively managed farmland. While the site does include some land classified as best and most versatile, the majority of the site, some 62%, is lower grade farmland, i.e. not BMV. This is consistent with the adjacent consented scheme, and it is also important to stress that the use is temporary and fully reversible. There is no permanent loss of agricultural land. The land will remain in active agricultural use through sheep grazing during the lifetime of the development. Soils will be protected and rested with enhanced soil structure and biodiversity over time. Critically, this development supports the rural economy, helping to diversify farm income and strengthen the viability of agriculture within a changing climate. While the proposed development will utilise the existing access from Nuthurst Lane, which has already been approved and constructed under the consented adjoining scheme. This extension will use the same entrance and track, no new access points are needed, and the route avoids any sensitive receptors. Because the developments are phased, there will be no overlap between construction and traffic, just a continuation of an already agreed and acceptable access strategy. Landscape and visual effects have been thoroughly assessed and found to be localised and
1
limited
minute outstanding.
with effective mitigation through planting and screening. Existing public rights of way are preserved, heritage impacts have been deemed less than substantial and well outweighed by the public benefits. Officers have confirmed that the site qualifies as grey belt under the updated NPPF, and that as a result, the proposal does not constitute inappropriate development within the green belt, an important and material planning consideration. The proposed development has the rare distinction of being a major infrastructure project with not a single objection, whether it be statutory consultees or members of the general public. All those who have reviewed the proposals have found them to be sound. In conclusion, this is a low impact, high benefit proposal with full technical support and a strong environmental case. We're grateful to officers for their professional and balanced assessment and for recommending approval, and we respectfully ask for your support, that you support the officers' recommendation this evening. Thank you.
Thank you. Members, do you have any questions? Councillor Wattles first and Councillor Parsons.
Hi, thank you for coming to speak to us. Obviously, you know that I've just read this and I'm interested now in how you propose to mitigate against the Skylark mitigation strategy. Just if you could outline that. I'm particularly interested in the size of the areas and where it borders, in the sense of whether it's tree areas or not. Has that affected the size of the space that you plan to use? Thank you.
So when you assess for skylarks, the ecologists do a number of visits and record the number of territories in the vicinity. There's a standard methodology for the number of territories you provide in mitigation. So we are putting forward that based on the 5 found, 10 plots are provided in mitigation within the wider arable farmlands. The plots are 4 metres by 4 metres within arable land where the drill is just turned off and left as bare ground. That is essentially how you produce the skylark plots. There are minimum distances that they need to be from hedgerows, so on and so forth, and when the detail is put forward in the condition, that will take all of that into account.
And sorry, just to add, I've just been sort of reading up on some of the extra conditions that are not highlighted in these very brief notes. And I noticed that it's right by a gorse, which I'm guessing, because I'm not very familiar with the area, because I'm at the north. But I'm guessing it means that there's a lot of trees there. And I believe that there's more conditions applied if it's a tree area.
So there's trees adjacent to the site and on the site. They've all been certified, had agricultural surveys undertaken. There's minimum buffers and protection in place for construction and operation.
I meant in regards to the skylark.
With regards to the skylarks, obviously that's away from the site, so it won't be within the site itself. It'll be adjacent farmland, and as I say, it will follow the guidance for where those are appropriate, and obviously the detail will be worked out.
I think that the plots have to be double the size, don't they, if they've got tree-lined areas?
I don't believe so. I believe it's normally just 4 metres by 4 metres, but obviously there is guidance on where those plots need to be. But as I say, when the scheme is drawn up, it will take account of the guidance and be drawn up by a suitably qualified ecologist and then submitted the discharge to the council, who I would then expect to consult with the county ecologist in discharging that condition.
Thank you.
Councillor Parsons.
Thank you, Chair. This is probably more of a personal request than what is the projected life of this site?
40 years.
40 years, yeah. Which, I think we need a new term. I mean, when I think of temporary, I don't tend to think of 40 years. I'm not. I do fully understand what you're saying, but I'm, almost temporary. Perhaps I don't know. But 40 years sounds a little less than that. But yeah, no, thank you for that clarification. That's great. Again, I have sort of anecdotal evidence that the solar farms can be distracting and difficult for waterfowl. They sometimes think that it's an area to land on and get a rude awakening when they try. But I mean, this isn't an area that in any sense interferes with waterfowl. And I don't know how true that. I think Dan would have played it. I'm reassured by the fact there's no water there. Yes. Thank you.
Councillor Cruz.
Thank you, Chair. I think it's really good news about the additional condition, and I'd just like to thank you that you've taken our skylarks into consideration, because they are ground nesting birds. But I still have great concerns on the bigger solar sites, as we say with our water birds when they think it's lakes and that. But thank you very much for considering our skylarks.
Just a couple of questions from me then, if I may. The report talks about best and most versatile agricultural land, and you referenced that in what you said. Given that 38% of this site is indeed best and most versatile land, at what level, where's the tipping point when you'd say it was too much? 38% sounds like an awful lot of best and most versatile land to me. At what point would you not develop it for solar farms?
So I don't think there's a hard and fast rule on that. I think, it's something that will have to go into the planning balance on any given site. I'm aware that there's been appeal decisions made recently where the proportion of best and most versatile land has reached as high as 70 to 80% and grade 2 in instances as well. Particularly over in sort of East Anglia, where there is a lot of high quality agricultural land, but also pressures from energy development as well. So I think it's I don't think there's a hard and fast rule for a tipping point, but obviously it's got to be factored into the balance of any planning decision.
In the report, and in your comments again, you mentioned grazing for sheep. As part of the evidence that was presented to the inspector at a recent appeal, there was significant evidence that actually these sites were unsuitable for sheep grazing. Do you have any examples of within your client's work of where sheep are grazed in similar environments?
So there are a number of sites that we have worked on as a company. None that springs to mind from that particular client. That I think this is the first project we've worked on for them. But grazing of sheep is a fairly common thing under solar panels. I believe Mr. Brown has put forward a condition within the report for the sort of framework that would be around that, stocking densities, things like that, that could help perhaps give you some certainty in that. I think anecdotally, it may be useful to know that a colleague of mine does keep sheep as a sort of hobby farming. He's around 100 breeding ewes, and he does graze under solar panels in North Somerset, and quite likes them because a fence, nice and easy to manage a sheep. They don't tend to get out.
And the sheep and skylights happily cohabit.
They do indeed. I think they like the shelter. We tend to keep the minimum the sort of low point, if you like, the leading edge, a minimum of 0.8 metres off the ground. That sort of allows them plenty of space underneath and means they can't nibble wires.
The evidence presented to the planning inquiry was very much that sheep grazing works on upland farms or on hill land, but not necessarily on flat land. And your view is that actually that they can work on both.
I would tend to disagree with that. I think any land capable of growing grass. I think traditionally more productive farmland would be used for growing crops. That's a higher margin agricultural activity. It's not to say that sheep can't be grazed on that.
And my final question is, I know some time ago we granted consent for the first phase, and this application talks about 40 years from the date that electricity is first exported. When do you anticipate that will be?
So, I mean, there obviously are a number of conditions attached to the proposed approval. As you can see, they will have to be discharged before the applicant then goes on to commence construction. It's normally around the 2-year mark to commence construction, and then once construction is finished, which normally takes sort of around 9 months for a development of this scale, we then look to energise the development and export energy to the grid.
So another 2 years?
2 to 3 years, I would say, is a reasonable estimate.
Thank you.
I have a comment rather than a question.
Well, if it's a comment, we should do it when we've released the speaker. Any other questions? In which case, thank you very much indeed. Councillor Derrick.
Thank you. Just to say that I was quite encouraged when I saw the site layout for this, that the existing hedgerows are supposed to be retained, and I would be very upset if further down the road, as it were, we suddenly found that it was no longer appropriate or no longer economically sensible thing to do, and that we then lost some of these hedges, which are quite well established. There are various trees also marked on the plan, and I would hope that they wouldn't accidentally get knocked over in the process of building it.
So I think in the conditions, Councillor Hayfield, there is a requirement for...
Councillor Hayfield,
sorry.
Please don't call me Councillor.
Oh, you're welcome with suggestions for that. So Councillor Derrick, my apologies. There is, I think, a condition that talks about a landscape plan. Is that right, Mr.
There
Rowe?
is, but I think it was worth making a comment that we do really value that aspect of it.
Can we touch on that?
Yeah, there are
condition,
two
Mr. Rowe?
conditions, Mr. Chairman. The first is condition 16, which is the landscape and ecological management plan, which goes through 15 or 16 points, all of which one of which is to do with monitoring as we go through, and for monitoring reports to come back to the council after 1 year, 2 years, 5 years, 10 years, 20 years, and 30 years. And then also condition 19, which talks about if the new landscaping fails, then obviously it's replaced within the first planting season. So, from a planning point of view, the conditions should allay your fears, councillor Dirks.
Thank you.
I understand what you just said, but that's all talking about the new stuff as opposed to what is there already, which is what I think councillor Dervix was saying. So is there any opportunity to amend condition 19 to refer to the existing and, if you will, historic land use?
I can look at that, Mr. Chairman, that's not a problem.
Thank you. Any other questions? Proposal? Someone needs to say something or we'll be here all night. Councillor Hayfield.
Why are we suddenly interested in skylarks? I mean, I've lived surrounded by green fields, pasture and arable land for the last 30 years. I've never seen one, let alone.
You won't see them, you hear them.
They're ground nesting birds.
Yeah. Jordan and Paul's have plenty of skylarks. Come for a cup of tea, I'll show you some.
Yeah, got some in Manchester and
And indeed, Captain Pugwash had a sky.
You're looking for a proposal.
I am indeed.
I propose acceptance of this.
And I will second.
Thank you very much. So it's been proposed and seconded that planning permission is granted along the lines talked about in and the conditions in the proposal. I'm sorry, I just had one further question, Mr. Brown. If you don't mind, I'll ask that. Mr. Brown, we're talking essentially about 40 years with essentially 2 to 3 year start period. Normally, we have a 2-year condition that work has to start within 2 years. Will this meet our standard conditions?
Well, yes, Mr. Chairman, condition 1 it deals with 3 years, to start within 3 years. So it's quite normal.
Okay.
Yeah.
I'm just keep mentally adding 40 years plus 3 years to my modest age. I'm
looking around the room, Dick's
like most of us, you're not going to see the end of it.
No.
Yeah, that's just what I was going to say, actually. It doesn't seem temporary to me because I've got no chance of seeing for.
And of course, all the lady members will still.
So there we go.
Sorry, before we vote, can we just have clarification on your proposed amendment to conditions, just so that we're all clear?
So it's an amendment to condition 19, which would provide protection for the existing trees and hedgerows and stuff here that Councillor Dervix was talking about.
Thank you.
But Mr. Brown will circulate the proposed wording so that everyone can see it.
Thank you.
If there's nothing else, members, it's been proposed and seconded for approval. Can I see those in favour? And those against? Those abstaining? Thank you very much. That's granted. We now move to application number 395 for Dunton Stables Equine Centre. Mr. Brown, anything to add to your report?
Yes, there's a further update, Mr. Chairman. Firstly, again, on your desks in front of you, there should be a note of the site visit. I'm probably missing one from Councillor Wackles.
On this occasion, it's a non-material.
Yes, this took place on last Friday afternoon, and there's a note there of that particular meeting. The reason for the update, Mr. Chairman, is we had a revised plan, site plan, red line plan, come in on Friday. But members on that site visit were able to view the site with that new site plan in front of them. It's a larger site that you can see there on the on the screen. It includes land right down to the motorway as well, so it's a much larger site. As a consequence of that, that's a material change, and I'll have to reconsult local residents and also some of the statutory authorities as well. So again, Mr. Chairman, I'm recommending a deferral, and in this particular case, as the information is all in, and re-consultation has started. I will aim again to get it back to you for the 9th of June, but I'm expecting all the consultation responses to be back before then.
Councillor Hayford?
Can I then move deferral, please?
Thank you. Members, before we do, I'd just like to understand why we have an appeal decision relating to a different site as part of the papers for this application. What relevance has it got? Appendix F.
Sorry, Mr. Chairman, would you?
This application has Appendix F, which is an appeal decision for a totally separate site. What is its relevance?
It isn't, Mr. Chairman. I'm sorry. I do not know why that's landed on the agenda. It is not relevant. You're correct.
Thanks very much. So if we can make sure when this comes back to us, that isn't in the future. So members, it's been proposed and seconded for deferment. Can I see those in favour? That's unanimous, I think. We now move to application number 142 and 143, which is in front of me because, as with the early ones, the applicant is not up for a council. Anything to add to your report?
Nothing, Mr. Chairman. This replicates work we've already done in other settlements in the borough.
It's been proposed and seconded. Can I see all those in favour? That's unanimous. Thank you very much. Andy, are you ready? So we now move on to application number 582 for land 230 metres west of Marston Fields Farm, Kingsbury Road near Marston. Mr. Banbury and Mr. Wright, welcome to the meeting. Mr. Brown will now introduce his report.
Right, thank you, Mr. Chairman. First of all, members visited the site on Friday. Again, there's a note which has been circulated for you. For those members that didn't attend, it's a bit difficult on this plan, indeed even on the aerial photograph. But we went to we walked along Kingsbury Road to the southern end of the site, where the roundabout is for the HS2 compound, and had a good look at the site from that end. And then we actually went round to the northern end of the site of Ossini Lane and had a good look at the site from that end as well. Quite a lot of time was spent at both locations, as you can see in that note and what was noted by members at that particular time. Again, this is a very similar approach in the report to that which we heard earlier on the Astley Solar Farm. The introduction of grey belts clearly has to be considered here. And that is what, again, the conclusion here. This is grey belt land in the green belt. And again, the conclusion is that it is not inappropriate development because it meets all the four conditions in paragraph 155. Again, so there's no green belt refusal opened here, in my view. So therefore, the matter of special circumstances does not arise. And as in the solar farm, you will have to consider the balance between harms and benefits. And these are outlined in the report that you have in front of you. The harm side of the balance is on 549, where you can see that the harm comprises moderate landscape and visual harm. And members will be able to understand, those members that visit the site will be able to agree or not agree with that, having been to the site. And then the applicant's considerations, in other words, the benefits, are outlined in the following section, and they are substantial, as has already been outlined, and they're repeated in the report. And again, in this particular case, Mr. Chairman, the balance, in my view, lies with the grant of planning permission. Thank you.
Thank you, Mr. Brown. Can I just check, members, that you've all got a note of the site visit in front of you? Thank you. Gentlemen, one of you, welcome to the Council House, the other one, welcome back to the meeting. Because you may not have heard it, my colleague will now explain the rules on public engagement.
Changes slightly when there's two. So in total, you have 3 minutes, which will be split between the two of you. I will stop you at 1.5 minutes, whoever's speaking first, and then the other one can continue. I'll start the clock when you start speaking.
Chair, members of the committee, thank you for the opportunity to speak today in support of this important application for a battery energy storage system at Marston Senior. This proposal represents a critical step towards delivering a more resilient and sustainable energy system. As members will know, achieving the UK's legally binding target of net zero carbon emissions by 2050 will require not only a dramatic increase in renewable energy generation, but also the infrastructure to store and deliver that energy when it's needed most, i.e. when you put your kettle on in the evening. Battery storage is the enabling technology that makes this possible. It allows surplus energy, such as that generated by wind and solar, to be stored when energy demand is low and released when demand peaks. This helps to stabilise the grid, reduce reliance on fossil fuels, and support the wider transition to clean energy. The proposed site was carefully selected for a number of reasons, including its proximity to the Hams Hall substation, its natural screening and low-lying nature, that has previously been developed and offers limited ecological value, and the relative lack of sensitive receptors in the immediate vicinity.
Throughout the application process, we've worked closely with officers and stakeholders and have responded constructively to feedback, including removing the large connection tower and instead proposing an underground connection to the National Grid Hams Hall substation. As a result, the entirety of the development has a low visual impact, with containerised units designed to sit comfortably below the existing vegetation line. To strengthen this further, we're proposing significant new planting and reinforcement of existing hedgerows along key boundaries. Over time, this will ensure that views of the site from public vantage points are extremely limited, and in many cases, it's screened entirely. Officers have concluded that while there is some landscape impact, it is localised, limited in scale, and not significantly harmful in planning terms. Crucially, officers have confirmed that the site qualifies as grey belt under the updated NPPF, and that as a result, the proposal does not constitute inappropriate development in a green belt, an important and material planning consideration. We acknowledge that a small number of objections have been received from residents within the locality, primarily in relation to fire risk. We have consulted closely with the local fire and rescue service at the pre-application stage and have submitted an outline battery safety management plan as part of the application. This document details how the proposed scheme complies with the National Fire Chief Council guidance, and as a result, Warwickshire Fire and Rescue have offered no objection to the application. The officer's report sets out a pre-commencement condition requiring the submission of a detailed battery safety management plan based on the detailed design and final equipment installed. Warwickshire Fire and Rescue Service will be consulted at the discharge of condition stage to ensure that the as-built design fully meets their requirements with regards to fire safety. It's also worth noting that battery storage has an excellent safety record in the UK when properly specified and maintained. This installation will be subject to strict operational protocols and regulatory oversight throughout its lifespan. In planning terms, the development complies fully with national and local policies on renewable energy, climate change, and public safety. The landscape and ecological impacts are limited and well mitigated. Technical consultees, including Warwickshire Fire and Rescue, the Environment Agency, LLFA, Highways and County Authority, all confirm they have no objection.
Members, do you have any questions? Councillor Parsons.
Yeah, if you can put it in layman's terms, because I'm definitely a layman here. What sort of storage capacity will this facility have in terms of the power it can hold and release?
So it's a 99.8 megawatt facility, which I appreciate is probably not layman's terms for you. Do you have any data on the number of homes that could?
Off the top of my head, I'm afraid.
No. We're talking a lot of power being stored, isn't it?
That's significant.
Okay, thank you.
Questions for the speaker?
Yes. Thank you, Chair. You mentioned that it's close proximity to Hams Hall. Knowing the areas I do, I would say it's not close to Hams Hall. It is quite some considerable way away. In fact, the opposite side of the A4097. And there's already an application that's been granted for battery storage at Hams Hall, i.e. right close to the National Grid sites. So I guess the question is, why would you just not make that one slightly bigger, rather than actually have a completely separate one that's going to require a separate substation underneath the pylons? I just kind of can't quite work out why you wouldn't just make the other one bigger.
So I mean, I suppose one would be availability of land, other planning constraints, etc. This site is available and suitable, i.e. it's previously developed, low ecological value. That would essentially be the rationale.
So Chair, if I may, just picking up, because I'm sorry, it is my previous role, National Fire Chiefs Council actually talks about lithium-ion fires, and its recommendation, which you quite rightly say is in line with that, is copious amounts of water and just wait for it to burn itself out. So there is still significant concerns around lithium-ion fires, because they don't go through the rule of the through fire, oxygen, heat, fuel. It is a chemical reaction. So once they start to burn, you cannot stop them burning, effectively, which we saw at the Luton car park at the airport. So I guess I'm a bit. I'd be interested in more detail on what the battery, like the management, fire management piece is like. I know you're going to put a lake or some water at the end, but that's effectively just managing that site. And so I think that's my concern is really around why there, because I'm aware of another one furthermore down Bodymoor Heath, which is even further away from Hensall. So I just can't see a very thin strip of land making that much sense.
So, I mean, as I say, in terms of the land, it's availability of land and it's being suitable in terms of it being previously developed, meeting, planning policies, etc., and within a feasible connection distance of perhaps all substation. So that would be the reasoning for that. But the site isn't huge; it's about 4.6 hectares, I believe. But that is substantial in battery storage terms. As I say, a 99.8 megawatt facility is very large. The fire guidance is very clear, and it sort of contains a number of requirements in terms of how you lay the site out, water supplies on site. So we've gone through each of those requirements and met them to ensure there is enough water on site. For example, the batteries are adequately spaced, etc., etc.
Could I just add to that as well, just in difference to the Luton incident, so obviously that was to do with a electric vehicle that caught light, so it wasn't subject to the NFCC guidance, it was just sort of an unfortunate incident. In regard to the actual containers themselves, they are each self-contained, are remotely monitored off-site. There's contact details that we put in by the management plans, and they have fire suppression systems fitted within them.
Thank you. Can
I having remote monitoring is all very well. How does that, does remote monitoring deal with the build-up that leads to that runaway event? Or is it only tell you once it's set fire to itself?
So it alerts you of anything that could potentially happen. So it's relating to the build-up. Yes, obviously, if there is an incident, it will also alert you, but it should have been well in advance of that.
Thank you.
Can I just sorry, from a size perspective on how much energy it can store, was it 9 megawatts? It was 99.8. How does that compare to the Hensall site?
I'm not familiar with the Hensall site.
I believe that's even bigger. Okay, thank you.
Any other questions? No, Councillor.
I've just done a simple Google search and it says such a facility capable of storing 99 megawatts of electrical power is equivalent to 300,000 UK homes worth of power for 2 hours. Does that sound?
I missed the number of homes, sorry.
300,000.
That would be about. So it's a large amount.
Any other questions, members? Councillor Bates.
Okay, I just want to come back to the point that you said that the remotely living in Kingsbury myself. Obviously, that's quite concerning in regards to how often does anybody go out and physically and have a look. Obviously, we're close to a lot of residential properties, quite a big village, both in Kingsbury and surrounding the area. So yeah, I suppose I'm just a bit worried about the coming back to fire and safety, the risk management of that, and what assurances have we got for the members of the community?
So remote monitoring is 24/7. That is always on and always taking place. Site maintenance visits as required, but as a minimum would be a couple of times a month.
Councillor Jarvis.
Thank you, Chair. The one thing that always concerns me with the modern batteries is the fire risk with them. Is there any sort of history of this style of battery, of its stability, the number of times you've had fires and how they're dealt with? I think it's one of the modern things that probably hasn't hit us fully yet. And it's something that's probably sitting a little bit in the background. And how stable are they?
And has there been any incidents with them?
So I've got some data on that here. So there's not been any fire with this technology in the UK. The only fires in the UK have been with the old-fashioned nickel manganese cobalt batteries rather than the lithium-ion BESS batteries. So there's been no examples at all of any technology since the implementation of the NFCC guidance either. So that was 2021, I believe. Yeah.
So it's been in existence for 3-4 years without any incidents. Sorry to come back, but just a secondary question. Has there been any testing of physically making them burn and then extinguishing?
I couldn't say for certain, but I would be reasonably confident that manufacturers would do commissioning testing and so on and so forth. I mean, they have inbuilt safety features for fire suppression systems, so they will be, testing the effectiveness of those.
It's not normal firefighting, is it? It's a
Can I
specialised
just
business.
probe a little bit further on that, because I'm aware the Dutch Fire Brigade set fire to an electric car with a battery similar to one car. They couldn't put it out. They put it in a tank of water, left it for, I think, a day or 2 days, poured it out again, and reignited. These are substantially bigger than what's going on in a private car. So I do think we need a bit more certainty on that.
So as I say, I mean, there are fire suppression systems inbuilt into the units. I think to a degree, all we can do is meet the National Fire Chief Council guidance, which we have done in this instance to the letter, and that is how your safety measures. So, for example, the 6 metre separation between batteries means that if you cannot put out the fire in one battery, it will not spread to the next battery and the next battery and the next battery. It could burn out on its own and be controlled in that fashion. I think it's important to remember as well that it's an incredibly rare occurrence. As I say, there is 4.7 gigawatts of BESS installed in the UK. And as I said, we've not had a fire with the online technology.
So I've seen four people. I think Councillor Parsons, Councillor Reary, Councillor Waffles, Councillor Walsh.
Thank you, Chair. Right, obviously we're looking at this fire risk and it is of concern, particularly for residents. Can you give us any idea of where are the nearest residents in location in relation to this site, basically?
That may be a question better directed at Mr. Brown with the aid of the plan.
I'll take the top plan, Mr. Chairman. Sorry, nearest residents are here, but of course the caravan site is here. The members saw that on the site visit. There are residences down here, but 1 or 2, I think. But the bulk of the residential properties are actually in Marston itself.
And can I just check then, in relation to that, Mr. Brown, there certainly used to be houses further along the 4097.
Yes, as I said, it's beyond the roundabout, the HS2 roundabout. Yeah.
So could I just ask, well, what do we think are the closest residents to this site?
But as a straight line across the fisheries, I would say that's about 400 or 500 metres.
Which is quite an exclusion zone, isn't it? Yeah. Thank you.
I think it was Councillor Reary.
You mentioned 24/7 monitoring. Can you just walk us through what that actually looks like? So if something happened at 3 o'clock in the morning, is somebody actually looking at the system, or is it, does it go to someone's phone and alarm? Exactly what do you mean by 24/7 monitoring?
So the technology will be monitored by us as well, but obviously that'll be a direct line to the Warwickshire Fire and Rescue Service, so they'll have the alert immediately.
Yeah, I was going to say, you explained about the 6 metres between batteries. What's in between? What is the flammable material other than the battery distance? Is that considered, I suppose, is the question.
For the most part, it's fairground gravel. I think in the layout we currently have, although that may be subject to change at the discharge of condition stage, it does show some inverters in between in some spaces at sort of a distance of 3 metres. As I say, that layout could be subject to change at the discharge of condition stage, and we would ensure that Warwickshire Fire and Rescue are happy with the distances
Yeah, so I'm
proposed.
just thinking, if the battery distance is considered, but then the next closest parameter might not be residential per se, but if it's something that could then lead to, I don't know, forest fire or whatever, then obviously.
Yeah, so the guidance includes distances from vegetation, combustible materials, et cetera, et cetera. So even the few instances where we have an inverter slightly closer, that's of course and still, it's like a shipping container, so not necessarily combustible.
Councillor Watson?
I think it's probably just worth mentioning, because you've said a couple of times about suppression systems within it. I think I'm right in saying they cannot be put out. They basically have to let them burn out, which is what the National Fire Chief Council recommendation is, and I quote, copious amounts of water and manage the fire. But they cannot extinguish it because it doesn't comply, it doesn't follow the rules of free fire, the free rules. It is a chemical reaction. So I think we need to be clear on that if one of these things go up, effectively it's a management rather than actually extinguishing. It's first point. And also there's toxic fumes that come off these things. So it's not just a fire like a woodland fire as such. There's actually toxic fumes, I believe, that come off these.
So I think, just as you were saying, that is only in the case of thermal runaway, which is rare, that it's a chemical reaction and can be put out with water. So the suppression system in the first instance may be able to put out a minor fire, for example, before it goes into thermal runaway.
Councillor Ridley?
Thank you. I know you've been in the hot seat for a while, but you said you're not aware of any fires in relation to any of the.
Not the lithium ion technology, to say all of the fires in the UK are in relation to the older nickel, manganese, cobalt.
Okay, you might want to look at the Fire Protection Association. There was a fire in East Tilbury on the 19th of February this year. The Fire and Rescue Service mobilised crews and the blaze, they had to tackle the blaze for almost 24 hours. The site, which is currently under construction, consists of multiple containers housing battery units. And it was a fault in one of the battery cells within a single containerised battery unit leading to ignition. So they had to use drones and thermal imaging cameras. And my concern would be, having been to the site visit on Friday, it's right next to a massive line of big electricity pylons. So that to me would be a real concern, and perhaps we need to review recent incidents and see how everything's happening.
So aware of the East Tilbury fire, I believe that was the old technology. I may be wrong about that, but even so, that was contained to a single battery container by means of the same fire strategy that we're implementing at this site. There was no risk posed or harm to the local community, and it was a BESS that was under construction, not actually in operation.
Councillor Bates?
Thank you. Sorry, you're all on the hotspot a little bit. I just want to come back to Councillor Ridley. I'm not sure whether I've not understood it or whether you've not explained it properly. But the question was the 24-hour, check-in. And could you talk us through that process? Because all I've understood is that the fire officers will be alerted, but I'm not sure what your process is for this 24/7 monitoring and what you guys do in regards to that. So is it just an automatic? If your house alarm goes off, it goes to a fire, the police or whatever else. Is it just that type of 24/7?
Yeah, apologies. I probably should have been a bit more precise on that. So it's obviously being directed through the National Grid. So that'll be the main point of call. So, in the event that there is any sort of incident that could potentially take off, it's automatic suppression. So it'll be shut off and disconnected. And then the local fire service and the National Grid will be informed. So, as a developer, we don't necessarily get to see that directly ourselves, but it's sort of the key stakeholders that will have activity in sort of having to reduce any harm or potential threat to the local public.
Councillor Burdick?
You were talking about the difference between or making a distinction between fires and thermal runaways. That doesn't mean anything to me. What is the difference between a fire and a thermal runaway? Because the end result is that a lot of heat that is uncontrolled and the combustion of the materials there. So what is the difference?
So as your colleague mentioned over there, thermal runaway is a chemical reaction, essentially. It's not the usual fire triangle that you would expect.
So why are we making a distinction between them when Yes, I don't understand why there is a difference in how you deal with those, because one is going to affect the other.
So Chair, if I may, because, so the fire triangle is oxygen, heat and fuel. If you take one of those away, you extinguish the fire. So if you can take one of them away, and that's how you fight traditional fire.
Yeah.
You either remove the heat, you remove the thermal runways, chemical reaction, it cannot be extinguished because it doesn't follow that rule. So you can starve it of oxygen, it will still burn. You can put water on it, it will still burn. So that's the difference.
Yeah, I understand that, but why do we need to distinguish between one and the other when they can be in the same place doing the same thing?
Scale. I think it comes down to scale. Gentlemen, we're all answering your question. Really confused your answer.
That's appreciated.
Yeah, it was just to go back on something that a little bit sort of expanding on this from what Councillor Watson intimated regarding the fumes. I'm just wondering how you would deal with that, you know, if it did get to this situation, how will you be guaranteed that the fumes are going to be dealt with or contained or appropriately or whatever is required?
So I suppose to a degree, land use planning is responsible for that and the sorts of separation distances that we're talking about here, obviously dispersion essentially. You know, you can't necessarily contain all fumes, it's all about limiting the scale of any very unlikely fire, which is why you follow the distances of separation, etc., to ensure that it's contained to one unit and not multiple units. I think, you know, this is all to a degree dealt with through the NFCC guidance, which is why they come up with the guidance in the way that they have, so that these sites are designed appropriately to limit the risk of fire in the first instance, but certainly large scale fires. So I think it's important not to lose sight of that guidance and following that guidance, which is what we've done in the design of the site, where that is known, where it is not, for example, due to final technology still being selected, that will be dealt with through the discharge of condition process, where the Forest Fire and Rescue would be consulted again, but obviously hopefully confirm there no objection in order for the discharge of condition to be dealt with.
Thank you.
So I just had two questions. Just think, why not? Everybody else has asked two questions. So my first one is, what happens during the development phase? So all of what you talked about, I think, works or could work when it's developed. But if something occurs during the development period, you have monitoring that will kick in that respect. And secondly, I perfectly understand that you've got this link to Warwickshire Fire and Rescue. I'm presuming that you've done some sort of preparatory work with them in terms of the disaster recovery plan and how they will get sufficient resource. Because as much confidence as I have in the Fire Brigade at Coleshill, you're going to need rather more than the appliances that they have at Coleshill, and how that will be escalated to get an appropriate response.
Yeah, correct. So we consulted with Warwickshire Fire and Rescue on a number of occasions. Firstly, before this application would have been even on the radar of the council, one of the first things we did was speak to North Warwickshire Fire and Rescue to ascertain their sort of standards for design of the development. So their feedback was directly put into the design of the proposals. They were then obviously consulted by Mr. Brown on the application. Initially, he came back with a few questions, which were dealt with, very small amendments to the application. Following that, they confirmed they were happy, it meets the guidance, and they have no objection. They will then obviously be consulted a third time on the discharge condition when that comes to it, on the very fine detail, which will include things like recovery, as you say. Sorry, remind me of your first question again.
During the development phase, monitoring of issues.
Yeah, so I mean, I think really that's just only when it comes to commissioning and there is actually electricity in the batteries, because obviously that would be the thing that would start the risk of anything at that stage would be more closely monitored, and it will feeds back to the same plan. And
sorry, just one other question, because I do see fires occasionally in my day job from solar panels and things like that, and I fully accept this is totally different. But one of the difficulties with batteries and panels and all the rest of it is how do you turn it off? Because that, as I understand it, is quite difficult, because once the power is in there, it is going to just burn itself out. Is there, I accept you're monitoring it and you've got the previous work, but how effectively do you actually turn off the power or stop the power that's within the batteries from igniting?
So you would isolate the unit. Obviously, you can't necessarily do anything about the power that is in the unit, but you can isolate the unit.
So what the battery that it was in would just have to burn itself out?
Correct.
Thank you. Anybody else? Because I'm genuinely conscious these chaps have had enough of the burning. Councillor Parsons.
Thinking about it, I think I want to make a statement rather than questions.
Excellent.
No, I'll hang on for a minute.
Look, gentlemen, thank you very much indeed. You get the prize for the most burning we've had for ages. So, thank you very much indeed.
Thank you.
Councillor Parsons.
Very welcome.
Thank you, Chair. For many, many years, I was a history teacher, and I visited many, many windmills and water mills in my attempts to inculcate my students with the knowledge of how energy is generated and the history of all that. And only one of the things that comes up in both water mills and windmills is the risk of fire. They were very much prone to fire because if the stones dried out, the heat built up and up they went. It seems to me that in any energy situation, there is a fire element, there is a risk of fire. And what you simply have to do is to look at that risk, mitigate it and deal with it properly. It seems to me that this site is reasonably well positioned with a decent exclusion zone around it, as it were. And, you know, I honestly don't know how you can have energy without a fire risk element. Well, I don't think it occurs. Thank you.
Thank you, Chair. I think just picking up on Councillor Parsons' point, what you can't see there is literally to the left of that line is the HS2 concrete fabrication compound. So that would have to be, in the event of fire, I will talk to us about that, that would be evacuated. So there would be potentially an impact there. I think one of my concerns with the site goes back to my earlier reference around the Hams battery site, the solar farm or the solar panels that's on the Environment Agency land. It is almost that cumulative impact of what all of the developments going on in this, what was once a very rural area, with HS2, with the fisheries, Mr. Brown's favourite development. It just worries me that, and I'd like to probably understand a bit more about the cumulative impact of all of these developments, not specifically a planning consideration for this, but I'd recommend almost a deferment of this to try to understand what's going on in the area and what the impact that has on the openness and what is currently green belt. And I know if you mentioned it's grey belt. So that's kind of where I would come from on this.
Thank you, Councillor Watford.
To go back on Councillor Watts, I feel like I'm tag teaming with you today. I appreciate what you're saying, but on the converse to that is that, you know, often when we're looking at large developments in rural areas and so on, we like to think that we can put things together that are of an industrial nature so that it's not impacting on our residential areas. So I suppose it's the balance of where do you put it in order to not then encroach on less desirable areas, I suppose is where I'm going with that. Just a statement, really. Thank you.
So, Mr. Brown, help us out with this. In 5.8, where you're talking about sprawl, you're saying these circumstances the site is not considered to strongly provide protection from sprawl. Is that the site as it is now, or as it may be, given all the HS2 work?
I stand by what's put in that paragraph, Mr. Chairman. Dealing with the grey belt, you have to look at the three purposes in the NPPF, and the guidance is quite specific about what sprawl means. It's sprawl of large built-up areas, to such an extent that these sites, in fact, I suspect what will happen, Mr. Chairman, is the majority of our green belt will be found to be grey belt when in fact we get the green belt assessment done on the local plan. So this in fact is following the comments in that paragraph are following the advice and guidance which is in the current PPG, the Planning Policy Guidance and NPPF. In terms of the cumulative impact, then there will always be a cumulative impact around Hams Hall because that is where the substation is. We've had exactly the same issue with the previous solar farm. There will always be a cumulative impact in the southeast corner of the borough because that is where the point of connection is to Bedworth. And all the solar farms that we've had in that part of the borough connect to Bedworth. So therefore there will always be a cumulative impact in that part of the borough. Just as we have here, we've got the Environment Agency solar farm, we've got the Dunton Hall solar farm, we've got this one, and we know there's another one coming as well. So they will always congregate around the point of connection. And that's the point here. What the strong point which I have to make, which came blatantly clear from the Forlongley solar farm inquiry and all of the other renewable energy inquiries that there have been, is that these particular proposals are reversible. I appreciate it's 40 years, but they are reversible. And when you're looking at openness in the green belt, that is a major issue when planning inspectors look at this particular matter. It's not the fact that it's 40 years, which is a long time, it's the fact that it's reversible. And that therefore it doesn't impact permanently on the openness of the green belt. And these particular features are all reversible. So that's another reason why it meets the definition of why it doesn't fundamentally conflict with the impact on sprawl.
I appreciate what you're saying. It was abundantly clear when we were at the site visit on Friday that, if you will, the unrestricted sprawl of Birmingham is up to this site because there is that development largely associated with HS2, which is next door. That's essentially the end of the conurbation at the minute. Therefore, surely this site must contribute strongly to the protection from urban sprawl because it's the first field as you get away from it. And wasn't that the whole point about Greybelt, that really in reality it's the first field out of the conurbation that becomes the important one rather than the ones in the middle of the Greenbelt, which was the argument over the site at the Forlongley solar farm.
I cannot accept that, Mr. Chairman. Birmingham does not end in the field opposite this site. Birmingham ends, as you would appreciate, effectively on our side of the borough at Pedimore, which is a good few kilometres away from this particular site. That's on the other side of the M42. Also, again, the HS2 compound is temporary. It's reversible. That is the consent of the Planning Commission. Whether we like it or not, it's reversible. It's got a temporary consent. And there are fields, as we know, on the other side of the motorway, north of Curdworth, and Curdworth running into Sutton and into Pedimore. You've got Wishaw, and you've got that particular area around Moxhole as well. Those are that is not proximity to this particular site. There's a substantial distance between this site and the current edge of Birmingham.
Till you fill it with Thrive.
Councillor Parsons.
Yeah, to go back to my previous point, there is no source of energy without risk, and that risk has to be assessed, and it has to be considered, mitigated, and dealt with properly. Seems to me that this is the case here, and so I think we could talk about this for a very long time. But as I say, there is no energy without an element of risk, and I think we have to accept that. We want renewable energy, we want clean energy, and I propose acceptance of this proposal.
Second.
I'll just say to you, it's not energy that brings risk, everything brings risk, but some of it is more acute than others, and if it's all dust. Dust is what creates the fire. Mr. Brown, I am acutely aware that other local planning authorities in the country have deferred consideration of battery applications for more information on fire protection and on disaster preparedness. I think I can't remember the last one, but I know there are some. I've been trying to find it. Where are the conditions in here relating to safety and the operation of the site?
Well, firstly, Mr. Chairman, go back to what the applicants have said in the fact they've already spoken to the fire rescue service in the preparation of this application, and therefore a lot of it's built in already. The comments that have come in. In terms of the condition, then I'll find it for you. It's condition 11. Now, I'm quite happy, and I'll have to consult the applicants on this. If you wish that particular condition to be expanded to include reference to a recovery plan, then I would be quite happy to look at rewording that condition. And bearing in mind the detail when that comes in will go directly to the Warwickshire Fire and Rescue Service for their comments. And I've got no problem at all with that circulating to local residents and other members that might be interested in it.
Thank you, Mr. Brown. I think that would help. Fire safety is paramount in my concern here, put together with the cumulative impact of development in this part of Greenbelt. Members, we've had a proposal from Councillor Parsons, seconded by Councillor Waffles. I'm sorry, Councillor Bates.
That's okay. Thank you. I think also in consideration is the Appendix G, which is from the fire department, which has got quite a lot of subject to the below listed within there. And I think it's really important as well that it does actually say that the amounts, because I do think it's about volume. We have got, others in close proximity. I do get in regards to is going to come risk, but when you've got so many all in the same sort of area, I think the risk becomes increased. And it does say here that, it does give rise for the hazards to be considered and seriously considered. So I just wanted to make reference to Appendix G.
Could I just ask, yes, it's a very good question, but where is the nearest site to this site?
Oh, you can't ask the applicant. You can ask Mr. Brown, but we've already well done. They've had enough questions, and we're well done.
Yeah, fair enough. But I'm just making the point. I think that yes, there's a concentration, but I don't see a concentration which is going to lead to a cumulative event. I cannot see that possibility in that sense.
Mr. Brown?
The closest approved battery energy storage is at Dunton Hall, which is it's going to be half a kilometre, 3/4 kilometre away from here. In fact, they're not visible. There's no intervisibility between the two.
So, as I was saying, we've had a proposal that consent be granted, proposed by Councillor Parsons, seconded by Councillor Waffles. Are there any alternative recommendations? Councillor Watson.
Yeah, I'd like to propose deferment until we understand fire risks better.
And that's seconded by Councillor Bates. Any other recommendations just for the avoidance of doubt? Yeah, I'm not clear as to which to take first. I know we had one first and one second, but one essentially cancels out the other. What is your guidance as to which motion gets voted on first?
Go for deferment.
Okay, so
Constitution doesn't state which one to go with, to be honest.
So we've had a proposal.
Very happy with that.
Yeah.
Yes.
Okay, so we'll vote on the proposal for deferment first. So the proposal, as I understand it, is that we defer further consideration until we understand more about fire safety. And are you happy to check in aggregation as well? So, members, all those in favour of deferment for those two reasons, please show.
I'll go with that.
I'm ready for that. 10. Yeah. And those against? clearly deferment. So, gentlemen, that item is deferred, and Mr. Brown will be in contact with you for more information around the board to become safer.
Mr. Chairman, in order to give guidance to the speakers, what exactly in terms of additional information is the board looking for to help the applicant in a further report?
I think that would be leading too much at this stage, Mr. Brown. I don't think members can tell you exactly what it is. They require greater comfort. So, members, we now move on to the next application, which is application number 89 for land 500 metres southeast of Lee Marston Shooting Club on Plain. Mr. Brown, anything to add?
Nothing to add, Mr. Chairman. The slides, as you see on the agenda, this is basically to divert a footpath as a consequence of the bunds, which have been approved at the shooting club at Lee Marston.
Any comments or questions? Councillor Watson?
Just one question. I know there was some early concerns around the width of the proposed footpath. Has that been resolved?
I could follow that up, Mr. Chairman. I mean, it would normally be 2 metres.
Yeah.
That's what I expect the county council to agree to, because that's their normal width.
I think the original proposal was narrower than that. I think you're absolutely right, and it may well be that that's now been resolved and he has agreed to do a 2 metre one. But
Yeah.
okay.
Anything else, members? Councillor Mooney?
A question for Ms Brown. Could you remind us when the approval for the bund took place? I'm just trying to, I can't remember exactly when we agreed to it. And just so I have in my mind how long they've had, if they haven't started any work yet, and whether that's a reasonable period of time.
It was granted last meeting, I recall, and the plan commission had to be started within 12 months.
So just to follow from that, Mr. Brown, is it likely that that will be achievable now, given the time period to get a footpath diversion resolved?
Well, I think the two can run in parallel, Mr. Chairman, but certainly if the board accepts this particular recommendation, I can certainly go back and get the update position from Mr. Breeden, who's the applicant for the bund. That's separate from this particular issue.
Okay. Look, I'm guessing here, but my expectation is that members would want the bund to be put in place as quickly as possible. So, you know, whatever we need to do with this application, I think we do need them to move together to actually not delay construction of the bund. Councillor Hayfield, Councillor Jarvis, Councillor.
I was about to say what you said, so I'll move the recommendation.
Thank you very much. Councillor Jarvis.
Storm of thunder, I'll send it.
Councillor Durham.
I was going to say the same as you as well.
Back to agreeing with each other. Given that, can I see all those in favour of? Thank you. We've done the application for butcher shop, so I think we're now on to the appeal update.
There's nothing to add. There's nothing to add to that, Mr. Chairman. It's two appeals recently dismissed.
Thank you very much. And agenda item number 7 is planning enforcement and man charges IT system. Anything to add to the report?
Nothing to add. We asked for an update, and we're getting on very well with DEF. From all the anecdotal information that we've had from other parties that are still working with IDOCs, it was the correct move, definitely.
Thank you very much. Anything to add, members? Are you happy to note that? Happy to note it. Thank you very much. I now move to agenda item number 8. All those in favour? Thank you very much. I don't know if we turn off the recording, do we, or we're done? Excellent. So agenda item number 9.